Also, in terms of a terminating plan, the plan sponsor is required to make any matching contributions or non-elective contributions for participants who've qualified for a match or non-elective at the time the plan was terminated. So they accrue whatever benefit they are entitled to up to and including the date of termination of the plan. Now, in the event of a defined benefit plan, a special notice of termination must be provided to participants of a plan that's subject to minimum funding requirements. So this does not obviously apply to 401k plans because there are no minimum funding requirements. So it's DB specific. It is considered a best practice to obtain approval from the IRS to determine whether the plan, upon termination, retains qualified status, and to obtain IRS approval before any plan assets are distributed. And in this process, by the way, can take up to a year, and typically does take that long, or potentially even a little bit longer. You should use forfeitures at this point to pay appropriate plan expenses, or they should be allocated to participant accounts. So forfeitures should be distributed. You should also, as a plan sponsor, take responsible steps to locate plan participants and solicit participant distribution election forms so all assets from the plan trust can be liquidated. Now, there are special steps that need to be taken to qualify as a reasonable attempt to locate missing participants. And some of these are online services or private locator services that should be taken. So know that there are some requirements that if you find yourself in that situation. Also, in terms of a terminated defined contribution plan, if there are missing participants after taking reasonable steps to locate them, the plan may distribute account balances to an IRA on behalf of the missing participants, or those amounts can be forfeited. Employers are responsible for filing returns on the 5,500 until all plan assets are liquidated. And then there is a final 5,500 required, noting the fact that this is the final form for whatever period of time might be considered a short plan year during which the plan is finally terminated. Now we're going to talk about partial plan terminations. A partial plan termination will occur in the event of two significant activities. One is a plan amendment to remove from eligibility a segment of the population. And number two is involuntary separation of service, layoffs, terminations, etc. There's a significant percentage that is looked on as a guideline to determine when the IRS would affirm that a partial plan termination has occurred. And that percentage is generally 20% of employees when they're no longer covered. That, as a guideline, is considered a partial plan termination or could be considered a partial plan termination. Also, a partial plan termination can occur based on reduction of benefits or potentially reduction of employer contributions as well.